Let's bring in Erin Hawley. She's an attorney at Alliance Defending Freedom who worked on the Dobbs case. She's also a former law clerk for Chief Justice John Roberts. Thank you very much for joining us. I want to dig into something because I am getting some reporting from the Supreme Court that there are people close to the court in this moment that are a bit worried about this statement that Susan Collins has put out and the rhetoric that she's using to basically claim that the justices lied to her. They're saying it's worrisome, especially because of the increased security needs of the justices, the conservative justices, in the wake of that leak. I wonder if I could just get you to respond to that, because here's her statement. Call 415 to our team. The Supreme Court has abandoned a 50-year precedent at a time that the country is desperate for stability, she says. This decision, she says, is inconsistent with what Justices Gorsuch and Kavanaugh said in their testimony and their meetings with me, where they were both insistent on the importance of supporting long-standing precedents that the country has relied upon. Obviously, the important thing to point out there is that the justice is saying that it's precedent basically means that it's the law of the land right now, but that can be changed, obviously. Many sources pointing out that she would not have a basic understanding of precedent. Your reaction?
Absolutely. So I think there's two key points to make here. And the first is that any nominee for a judicial office, including and especially a Supreme Court justice, cannot forecast or predict or promise how they will rule in any particular case that might come before them. Every year, the Supreme Court gets abortion cases. And so none of the justices that are on the court have forecast or predicted or promised how they would rule on Roe versus Wade if a case came before them. And the second thing is, exactly as you explained, the fact that a case is precedent simply means that the case has been decided by the Supreme Court. It is entitled to respect and must be followed by the lower courts. But the Supreme Court can and does reassess precedent. As the Supreme Court opinion in Dobbs points out, some of the greatest decisions of all time have been decisions in which the Supreme Court overruled prior precedent. Take Brown versus Board. That unanimous Supreme Court decision, one of the most important in our nation's history, and overruled the separate but equal doctrine of Plessy versus Ferguson. So no, the justices did not lie.
Yeah, and it's interesting, Erin, because we see at the bottom of the screen there you were a former law clerk for Justice Roberts, and there was some early reporting came down. The decision was 5-4. No, the decision was 6-3, and Justice Roberts, of course, concurred with the Dobbs ruling here. What do you think about Justice Roberts' opinion in this, kind of pulling back from going after Roe?
So, well, Chief Justice Roberts nowhere says that Roe was rightly decided. What he says is that the court didn't need to overrule Roe in this case because they could uphold Mississippi's law on other grounds. So it's absolutely a 6-3 opinion. So you have a supermajority of the Supreme Court upholding Mississippi's law, which applies at 15 weeks, and you have 5 justices clearly laying out the case and explaining why Roe was wrong on the day it was decided, and it has only gotten worse over time. So Roe was an egregious decision, and it should not have taken 50 years for the court to overrule that case.
I want to get this in as well because in the wake of that leak, obviously, in the protests at these justices' home, Kevin McCarthy drew this conclusion based on the decision that just came out. Listen. I'm sorry, SOT 16, if you can pull it up. Basically makes the point that they were not bullied by the far left, the Supreme Court. Listen.
The Supreme Court was not bullied by the far left mob. Threats of violence against the justices did not win. And the truth is, pro-life Americans are not planning a night of rage. The reaction to this principled decision by the court, it must be peaceful. And the DOJ must step up to protect our justices, their families, churches, and pro-life pregnancy centers from unprovoked violence.
Just wanted to get your reaction to that, Erin.
I absolutely agree. And I think this was a very brave decision by the Supreme Court. They decided based on the law and the Constitution, not on public opinion. The court is at pains to note in there, they take to task the prior court in Casey, which decided that Roe could be upheld, even though even a plurality of justices couldn't agree in that case that it was rightly decided. But the court upheld Roe anyway, and they did so on the basis that they were going to call the nation, the contending sides of the debate, to sort of peace. And of course that has not occurred because it is not the Supreme Court's job to find a right to abortion in the Constitution.
You know what,
so
I was
absolutely.
Go ahead, Erin, I'm sorry.
No, so absolutely. Department of Justice should defend churches and pro-life centers, and the justices bravely stuck to the Constitution's text and history, so I commend them for that.
Yeah, I was going to say I was kind of fascinated by the reaction of the Obamas, and this, by the way, Control Room, was call for 13. The president came out against the decision, of course. Here's Michelle Obama's reaction. She says, quoting here, "I am destined to learn the painful lessons of a time before Roe was made law of the land, a time when women risked losing their lives getting illegal abortions. Our hearts may be broken today, but tomorrow we've got to get up and find the courage to keep working towards creating the more just America we all deserve. We have so much left to push for, to rally for, to speak for, and I know we can do this together." It's interesting to me because, as we've noted, the former president is a constitutional law student. He's an attorney, so he knows what he's talking about. He knows very well that Roe was never a constitutional issue, Erin.
Absolutely. As the court's opinion lays out so eloquently, there was never a right to an abortion in the Constitution. And moreover, this decision doesn't take away rights from women. It allows states to protect the unborn and also to empower women. There are studies that show that 75% of women who obtain an abortion would have chosen life if they felt they would have had the support. So here, states are allowed to come alongside women and to make sure they and their children can flourish.
Okay, we really appreciate you joining us, Erin. Thank you very much on the breaking news.
Thank you, Erin.
Appreciate your time.